我哋夠法定人數呢。
Good morning, members. We have formed a quorum. This is a meeting of the Bills Committee on United Nations Anti-Terrorism Measures Amendment Bill 2017. This is the second meeting of the Bills Committee. Today we have invited deputations to give their views. So may I now ask our Secretariat staff to invite the deputations and individuals to join us now.
唔該晒。好啦，我哋歡迎保安局嘅副秘書長。
I'd like to welcome Ms. Mimi Lee, Deputy Secretary for Security from the Security Bureau. Also Ms. Iris Lee, PAS. And we have also got from the DOJ, the Deputy Principal Government Counsel, Ms. Anthea Lee, Ms. Carmen Chan, and Ms. Osa Chan, and Mr. Gary Lee.
等啲團體同埋代表咧係進場嚇，唔該。早晨。好啦，嗱，各位同事，我哋先。
Good morning, members. We'll have our public hearing first, and then we would take a break before we proceed to the next part of the meeting. May I remind our guests, you can see that we have simultaneous interpretation. You can adjust the channel as appropriate for Chinese and English channels. Please also be reminded that your speeches made today are not protected by the Legislative Council Powers and Privileges Ordinance. In other words, you have to bear responsibility for what you say. And the Secretariat has also given you a leaflet on the notice for members of the public attending meetings in this council. We have also received 2 written submissions as today. We have also referred 211 submissions to members, and these parties will not attend today's meeting. So, first one, Dr. Zhang Chapman. You have 3 minutes. I will ask you to stop when time is up. Dr. Zhang. Chairman, members, good morning. I'm Zhang Chapman. Are we going to result in discrimination against Hong Kong people under the Bills Committee on UN ATM Amendment Bill? If no one can leave Hong Kong for the purpose of planning or perpetration of terrorist training. This goes against Article 31 of the Basic Law, under which we enjoy freedom of travel, and also Article 105. Hong Kong SAR government protect right to poverty, and also universal human rights, a Declaration of Human Rights. The Hong Kong SAR government may deprive the dissidents and Hong Kong residents of the right to travel and their right to property, as long as you can label them as terrorists. But there may be a reason for doing this. Last year, during the Lunar New Year, the government labeled the incident in Mongkok as a riot, and also the new CE, Mrs. Carrie Lam, said that independence of Hong Kong is not part of freedom of speech, and Mr. Junius Ho said that all the pro-independence people should be killed without mercy. And so if you travel with the intent of planning and perpetrating and training of terrorism, you'll be caught. So the bill can be made use by the SAR government to make us treated like Mr. Liu Xiaobo. With regard to the UN Security Council, the Resolution 2178, the relevant provisions and articles would be applied to Hong Kong permanent residents, including mainland Chinese nationals residing in Hong Kong. So the Security Bureau is excluding the mainland residents living in Hong Kong. Are you advocating independence of Hong Kong? So are you trying to let go the mainland residents living in Hong Kong and instead of ISIS terrorists, who have never been in Hong Kong? We must stop this bill. I think all Hong Kong permanent residents should say no. Mr. Yin Pak Leung, Chairman, good morning. The September 11th incident in 2011 is still fresh in our memory. The world has been under the long shadow of terrorism. Recently, we have lone wolf terrorist attacks, which seem to be spreading. So we have seen the impact on our livelihood and our security. Although Hong Kong has not been attacked, but the possibility is always there. And we should be prepared. Hong Kong is an international metropolis. We have lots of visitors, travelers from all over the world coming in and out of Hong Kong. So there's a definite possibility that we may become a target of a terrorist attack. We are very concerned about lone wolf type of terrorist attacks. Compared with group terror or organized terror, this is even more difficult to prevent. So individuals can plan on their own to attack. The planning is simple for them. Resources required for such attacks are limited, but such attacks can cause a lot of panic in the community. They don't need to have a direct liaison with terrorist groups before they do so. So such attacks are difficult to prevent, difficult to predict, and our law enforcement agencies will find it very difficult to prevent such acts. So these criminals, unlawful elements, can easily escape the arrest. So we should not sit by with folded arms at the developing scene of terrorist attack all over the world. Lone wolf terrorists can move around the globe. The travel industry is in contact with a lot of people from different walks of life. We should do our part. We in the travel industry should do our part and inform the authorities of suspicious people. We support the government's bill on anti-terrorism measures, but we are equally concerned that the implementation details should be well thought out instead of so that we would not make innocent people suffer. I support the broad principles of the bill because Hong Kong's risk level is rising and at the time. But there are problems with the definitions. For example, terrorist acts. There can be a variety of many of the variety acts, acts targeting personal safety, property, the life of other people other than the victim. So terrorist act is widely defined in Hong Kong. This is done in response to the UNSCR resolution. I think we should tighten up the provisions in the bill. With rising terrorism risk, we should adopt a targeted approach and narrow down the definition. We are talking about mainly, for example, Al-Qaeda and IS and other terrorist organizations. We should crack down on their activities ruthlessly. If the Security Bureau is aware of individuals and organizations who may be in liaison with such terrorist organizations, they should take action. But this bill adopts a double standard in respect of freezing of property. Court order is required. But for the prevention of people to travel, it will only take the CE or the Secretary for Security to indicate that a certain person is expected of trying to travel to receive training, terrorist training. But such allegation should be subject to court scrutiny, like we had like we did in the past. If there is court scrutiny of such prohibition, it would better safeguard Hong Kong people's right to travel or freedom to travel. And we should also narrow down the provisions so that they only apply to the UN-designated terrorist organizations. For example, there are different definitions around the world. Japan, they have their own list. In the past, the UK regarded the Northern Ireland Republican Army as a terrorist organization. So there have been cases of abuse. So that the government should pare down the definition and narrow down the definitions. Ms. Yang Cheng, good morning. We need to have provisions to prohibit the dealing of terrorist property and also to prevent terrorist financing to improve security. But I have a few questions about the bill. There should be a clear definition of property. Under the UN ATMO, what is the definition of property? Do we want to include personal effects, personal chattels such as jewelry and overseas properties? So how can we make sure that Hong Kong people will not inadvertently deal with terrorist property? For example, if someone cleans up the property of the real property of a terrorist, which he or she only finds out afterwards, would he be regarded as having to deal with a terrorist property? For 8A1B, clause 8A1B, properties are owned or controlled by terrorists. For B, or property owned by a terrorist. And there is a so-called disclosure exemption, are you saying that after the disclosure is made, you can deal with terrorist property? So isn't the government contradicting itself? The ordinance has been in place for more than 10 years. What if when information is received, what will follow? What will be done to follow up? How many cases have been received by the government? How can the relevant parties inform you, and when? Is rather vague. The government should give guidance to the relevant trades and people of Hong Kong. Thank you.
Next, Mr. Pan Chongfu, Chairman, members, good morning. I personally support the United Nations Anti-Terrorism Measures Amendment Bill 2017. And I think that it should come into force as soon as possible so that Hong Kong's legal system can be more complete and our counter-terrorism capability can be improved. Now, other than this bill, do we have other ordinances or international conventions which may assist the Hong Kong government to tackle terrorists? As we all know, there are new and more various forms of terrorism or terrorist acts. For example, the lone wolf activity in Las Vegas, that is something we have never seen before. So we cannot just rely on one ordinance. In particular, the amendment of bill has always been slow. It always lags behind the times. In Hong Kong, we have heard threats about bombs. Fortunately, nothing serious has happened so far. But for bomb attacks like this, can Hong Kong really cope with them? Anti-terrorism is top on the international agenda. So are all the anti-terrorism treaties and conventions implemented in Hong Kong? If so, when did they come into force? And what's the situation of the implementation? I hope the government can promote more so that the public would feel safer. They would know that the government is doing something and we have the necessary laws to protect us. Thank you. Next, Mr. Chen UK. Thank you, Chairman. Good morning. I agree with the government. Any form of terrorism financing should be banned. That's why I support the amendment bill. But I also hope that the government can explain to us how can the public know that a certain property belongs to terrorists or that property has been frozen. According to the UN resolution Rule 6, it is said that a written notification would have to be sent to the holder of the relevant property. And if a written notice cannot be successfully sent, then should the property holder be held responsible? And also for Article 6 or for Section 6, I think you are already imposing a lot of burden on us, and now you're adding Section 8. So those sort of pressure will be even more. And what is the definition of property? What do you mean by directly or indirectly handling the property? And how about the property outside Hong Kong? So I hope that the SAR government can give us clarification concerning such requirements. Otherwise, people may fall victims to the new law. Next, Mr. Lee Chi-kang. Chairman, members, officials, delegates, my name is Lee Chi-kang. With regard to the government's proposed United Nations Anti-Terrorism Measures Amendment Bill, it prohibits people from going to other states to perpetrate terrorist acts or receive terrorist training, and the subsidizing of such travels will also be prohibited. This is something of good intention, and it can also enhance Hong Kong's counter-terrorism capability. It's worthy of our support. However, for this bill, when it's compared with other international conventions, what is the situation like? Because lately we have seen a series of terrorist attacks in other countries, and many countries have regularized their anti-terrorist strategies. For example, the UK laws have authorized their governments to impose bans on their citizens so that they cannot go to certain countries, and sometimes even their passports are confiscated because of this. Can Hong Kong's practice be in line with international practice? Second, for the present bill, when it comes to protecting the safety of the people and the security of the public, has the government done enough? Has the government enough confidence? If this bill is passed, if someone seeks judicial review against the bill, does the government have the confidence to win the case? And how does this bill compare with the relevant laws on the mainland and in Macau? Is it in line with the UNSCR? I have a number of questions. I hope the government can give me answers. Thank you. Last one, Mr. Zhang Xingyin. Thank you, Chairman, members. Good morning. My name is Zhang. Mr. Zhang, can you speak into the microphone, please? It's to facilitate our interpretation. Yes, the red light is on. I'll give you back some more time. I speak on behalf of the Hong Kong Chinese Importers and Exporters Association. Hong Kong is one of the safest places in the world. However, terrorism knows no boundary. If Hong Kong is involved in terrorist attacks, it will definitely have a huge impact on our business, industry, terrorism, etc. And this will deal a huge blow to Hong Kong's economy. Well, for terrorist attacks around the world, we have seen changes. Initially, it was of huge scale. For example, 9/11, and then now it's evolved into lone wolf acts. Lately, we have seen such an attack in Las Vegas, though it's still not defined as a terrorist attack yet. We support that the government should take effective measures to prevent all forms of terrorist acts. Now the government is amending the bill. It aims to prohibit Hong Kong people from going to other states for terrorist acts or terrorist training, and it also prohibits the financing of such travels. I think we need these prohibitions urgently. Our association supports the government. We hope that the bill can be passed as soon as possible so that Hong Kong's counter-terrorism capability can be enhanced, and it can also show that Hong Kong as an international financial center is willing to take up this international responsibility so that our international status can be enhanced and Hong Kong's public security can be ensured. And Hong Kong is also a place which respects human rights. So I hope that when the government explains the bill to the public, it should tell us how it can enhance its counter-terrorism capability and at the same time protect the basic rights of Hong Kong people. Yes, thank you. Our delegations have all spoken, and 6 of them support the bill, 1 objects to it, and another one expresses concerns. I think, Deputy Secretary, maybe you would have to address the questions. Now, would this bill limit the freedom of travel of people, and would the government have too much power? And what's the definition of terrorist act? Can it be narrowed? And what's the definition of property, etc.? So I hope you can answer these questions first, and then I will give the floor to members. Deputy Secretary. Thank you, Chairman. And also I would like to thank the deputations for giving us views. I heard from the speeches that some of you are concerned about the definition of terrorist acts, whether it would be too narrow and whether dissidents would be persecuted. As for the Hong Kong laws, we have a definition of terrorist acts. It's very clear and it's in great details. It's in Section 2 of our bill. It means it involves serious violence or serious incidents which may harm people's life or properties, and it may be damaging our infrastructures, etc. So when we drafted the bill, we have already taken human rights and citizens' rights into account. And there have been some exemptions. For example, the expression of views, the promotion of views, industrial actions, etc. All these are not included in the definition of terrorist. This time around, we are not amending the definition of terrorist acts. And also, we are not amending the definition of terrorist associates and terrorist property. So so Section 456 of the bill will not be changed. The United Nations will issue a list from time to time, and this will be gazetted and included in our ordinance from time to time. We do this in accordance with the UNSC, and the ordinance also gives the CE power, and the judiciary will be our gatekeeper. The CE will put forward reasons and grounds, and if the judiciary thinks that certain people or acts are comply with, or they in line with the definition as stated in the bill, then actions will be taken. But we have never invoked this section. You shouldn't be too worried because we follow all the recommendations of the United Nations. And just now you talked about human rights. As for our proposals, we work in accordance with a resolution of the United Nations Security Council, because this resolution aims to combat terrorism or terrorist fighters. Because in the past years we have seen this, we have seen people going to other states, for example, Syria, and then they receive terrorist training, and then they go back to their original country, or they even go to other states to carry out terrorist acts. Now, UN has taken this into account, and that's why after years of discussion, it's passed the latest resolution. So for all the member states, in the case of Hong Kong as China, That is, all the member states should regulate their citizens. And if they have concrete proof that a certain citizen is leaving the country to receive or provide terrorist trainings or to be involved in terrorist acts, then that person should be subject to criminal sanctions. So that's why we are amending the bill. Now, of course, we are very concerned if we do this. We will violate Article 31 of the Basic Law, because for Article 31, as you all know, is very clear, and it says that Hong Kong residents shall have freedom of movement within the Hong Kong SAR and freedom of emigration to other countries and regions. And also, Hong Kong citizens would enjoy the relevant rights. But it is stated very clearly that this is not an absolute freedom. There will be reasonable legal constraints. Now, in order to combat terrorism, now we are proposing this. That is, for people who are perpetrating, planning, or preparing or participating in terrorist acts, and for people who are providing or receiving terrorist trainings, and if they are leaving Hong Kong to other states, this would be a crime.
So not in any way affect the freedom to travel of our citizens. And this proposal can help us fight terrorism, and the target is clear. We're talking about specified targeted individuals who are leaving to do what I have just said. Since this is a criminal sanction, the burden of evidence is on the police and the relevant law enforcement agencies. The prosecution must adduce sufficient evidence to substantiate the prosecution case, and the court would only convict if it meets the highest standard, and there should be no reasonable doubt. For example, we are talking about people who are going to receive training, who are going to participate in terrorism activities. We're not talking about ordinary people. The freedom to travel of ordinary people will not be affected by this proposal. We are targeting the bona fide criminals. We believe this represents a reasonable balance and is fully in line with the basic law. It's been said by one of the deputations that the prohibition targets Hong Kong permanent residents, and he asked why. Well, the bill is introduced to conform to the UNSCR in question. Every member state has to find its own ways to implement the resolution because of different circumstances. The relevant laws in all these member states will be somewhat different. For the Hong Kong SAR government, we go for prevention, and that is we want to nip the bud of terrorist training. If we know that someone is going to leave Hong Kong for the purpose of receiving terrorist training, we would make it an offense. We will stop it. The UN talk about regulating the nationals of the member states, but Hong Kong is not a sovereign state. So we interpret this to mean the Hong Kong permanent residents. So the question follows is that what about non-permanent residents? Are we going to have a big loophole? The answer is no. The law has to be based on the UN Security Council resolution. The UN SCR talks about state of residence and state of nationality. We have the principle of one country, two systems in Hong Kong. It's difficult to come up with something which actionable, and a lot of technical difficulties will be involved. We need to have a piece of legislation that can be acted on, and it should be simple and easy to understand, and of course it has to comply with human rights. So this prohibition is imposed on permanent residents. But what about non-permanent residents? If Hong Kong law is broken, such non-permanent residents will be brought to justice, because there are other laws to combat terrorism. One of the deputations talk about some other international conventions. So I was talking about those. We can arrest these people for violating Hong Kong criminal law. But if the person has not yet committed any offense, and we have intelligence knowing that he's about to leave Hong Kong for another country, and that person is not a permanent resident, and under the international cooperation regime to combat terrorism, and also under the cooperation system of Interpol, we can share intelligence with other jurisdictions. So when that non-permanent resident leaves Hong Kong, he may expect someone to receive him at his destination. And in that other jurisdictions, they may know that particular individual better, and they may be able to bring that person to justice. So there's no need to worry about the case of non-Hong Kong residents, and whether such residents would escape law enforcement. And I said that the travel industries do not like to see black sheep among them. We don't want anyone to assist or facilitate the travel of such individuals. But if I'm a travel agent, I'm a hotel operator, I don't know much. If there's no mens rea in question, then there's no question of committing an offense under the bill. If something is done without the necessary mental element. But if you knowingly provide the assistance and the facilitation or organization of the travel, then it's likely that an offense will be committed. The trade has nothing to worry about, because we want to catch terrorists and rook service providers. So if you are not doing this intentionally, you have nothing to be worried about. We've asked the police to maintain close communication with the trade. They are already doing this in respect of commercial fraud and other criminal matters. The police attach a lot of importance to good communication. After this bill is enacted, we would ask the police to maintain close communication with the trade. Of course, if a citizen want to make a report to the police, they can always dial 999, but we can also give the relevant parties another direct line to the commercial crime. 2527-7887. We'll inform the relevant parties about this direct line, and we welcome suggestions on how we may further assist them. We want to receive any information on terrorist activities and behavior. Can we really bring criminal elements to justice effectively? Well, the court will have to make the final ruling in the light of evidence and the circumstances of the case. But at present, since we don't have this bill, the court can do very little. The amendment bill aims at incorporating more provisions into the UN ATM ordinance. Many deputations have touched on property and the definition of property. This time, we do not propose any amendment to the definition of property. In the UN AMO, there is no definition for property, so we fall back on Cap 1. That is to say, Section 3 of Cap 1, which defines property. Money, goods, including money, goods, financial instruments, obligations, and rights derived from such properties, profits, gains, whether present or future. Vested or to be vested. And please note that it doesn't say that this is confined to what we can find in Hong Kong. According to lawyers, it will cover overseas property. So if we want to freeze a terrorist property, it's not just effective within Hong Kong. If a terrorist owns property all over the world, all the different types of property will be frozen wherever situated. Only by doing this can we just cut off the financial resources of terrorists. What is meant by dealing with? What about directly or indirectly dealing with property? Well, this is in the ordinance, and we are not going to change it. It's a bracket 6. It's a section 6 bracket 12 in the ordinance. Receive, conceal the property, conceal the origin, the location, disposal of, and dealing with any rights derived from the property, or conversion of the property into another form, moving the property into or out of Hong Kong, or using it as a collateral for a loan is part of dealing with the property. This is a clear and rather detailed definition. We have no intention to change it. So dealing with property, dealing with will be handled as it is in the ordinance. And also under Section 12, if someone knowingly or suspects that a property is terrorist property, then disclosure must be made to the an authorized officer. In this context, we mean the police and the Customs and Excise Service. They have a joint investigation task force on anti-money laundering. So for this ordinance, for this bill, we have different law enforcement agencies involved: police, CNE, Immigration Department, and ICAC. And when many parties from the financial sector would make reports to the joint task force.
In 2011, Asia, of this joint group, it received over 20,000 cases, and then up to 2016, the number increased to 76,000. Well, are there many more suspicious cases in Hong Kong? That may not be the case, but the awareness of people has been advanced, and for many industries, we are happy to see that they have issued guidelines telling their practitioners that they have the legal responsibility to report any suspicious cases. And disclosure is also very important in our policy. Now, the chairman may ask, why do you ask people to disclose? It's so much trouble. Well, for terrorists, they are not common criminals. They would intentionally conceal their properties. It's very difficult to find out. And also, they would launder the properties, and you would think the money is clean. So it's very difficult to investigate. So reporting is a very important clue. We must build this blueprint. Then our law enforcement agencies can follow up. So we attach a lot of importance to this. And we are very happy that the relevant industries are doing better and better. And of course, our investigation team is having a bigger burden, and we are considering adding more manpower to it. So for disclosure, the relevant industry practitioners can be free from responsibility if suspicious cases are reported. Well, some people asked, how does one know that a certain property is frozen? Well, under our ordinance, there is a Section 6 that's about the freezing of properties. Now we already have a mechanism. Now, if a property is frozen, the government would have to issue a notification to the property holder. For example, if it's an account, if the account is frozen, then the administration would have to issue a notification to the bank because it's the property holder, and then the property owner would be notified. That is the account holder. That's the account owner. And of course, you have to exhaust all means to send a notification. With some criminals would try their best to evade this. However, under the law, if you have exhaust all means or done your due diligence to send the notification, so the other party does not receive it, that will be considered acceptable. Then the account will be frozen. Well, a lot of protections would be given to the person affected. Though if a person's account is frozen and he cannot even pay salaries to his cleaner or his driver, etc. So this third party should not be affected. The Secretary for Security can issue instructions giving exemptions. That is, a certain amount of money can be taken from the account so as to pay salaries to certain people. And or you may say that, well, this is not terrorist property. You shouldn't freeze it. So you can go to the court to make an application. So the court will be the gatekeeper. Or you can say that you have mistaken. You are saying that this is terrorist property and I'm a terrorist. This is wrong. I need compensation. Well, we also have a compensation mechanism. In 2002, the LegCo has already scrutinized all these. And now we are not amending Section 6 of the ordinance. It will stay intact. But this Financial Action Task Force, an international organization against money laundering, it says that for freezing property, it involves a lot of procedures, and it may take at least 1 or 2 weeks. And the terrorists might have transferred the properties away. So we are accused of being too slow, and we have to make improvements. And when we look at other countries, they do the freezing immediately. That is, if the United Nations say that you are a terrorist, your properties will be frozen immediately. But Hong Kong hasn't done that yet. So this time around, we hope that we can achieve this. Just now, a member asked how our law is compared with laws in other countries in this regard. In Hong Kong, we have a comprehensive system to ensure that we are protected from terrorist attacks. As for our practices, they are in line with international standards. For terrorist acts, many of them can be punished by Hong Kong laws. For example, the crimes ordinance and the body injury ordinance, etc. So all the injuries concerning people are covered. And also there are international conventions handling terrorist acts, for example, financing terrorists, bombing, multinational crimes, etc. So all the relevant international conventions are implementable in Hong Kong. In Hong Kong, we also have the fugitive offender ordinance, etc., so that we have international cooperations. Just now, a question was asked. Well, you know that terrorist attacks may always involve bombs. For example, the Boston Marathon, it was a lone wolf attack, but it also involved bombs. So we are not only relying on this ordinance. For public security ordinance, it covers sections concerning bombers. If a person places a bomb at any place or transported by sea or by land to a certain place, and it aims to make people believe that this object may be on fire or may explode and leading to bodily or property harms or damages, that would be a crime. The fine is $15,000. Well, this is just about a threat and an imprisonment of 5 years. So this is just one of the examples. Of course, there are other examples in Hong Kong, for example, the possession of explosives, gunfires, etc. So we have a whole anti-terrorism system, and this ordinance is one of the links. As for comparing our ordinance with other countries' legislations, some people mentioned the mainland practice. Well, for the UNSCR 2178, we can see that for many common law countries, for example, Australia, New Zealand, Canada, they have already implemented Resolution 2178 through their local laws. For example, Canada, for people who leave Canada to assist and terrorist acts is already regarded as an offense. And for Australia, if you are departing Australia to receive terrorist training or entering other states to carry out hostile activities, is an offense. And of course, financing such acts would be an offense. Well, for some states, their interpretations are even more aggressive. For the UK, a police officer on the street can confiscate anybody's passport. Then you cannot leave the country. Well, we are not trying to raise with them, but we have to do our part. In our country, they have already implemented the relevant laws. For example, anti-terrorism ordinance. They have included all the prohibitions that we mentioned just now. And also in May 2017, Macau has already implemented all the recommendations in the UNSCR 2178. Thank you. Deputy Secretary, well, can you write down all the salient points that you mentioned just now in a paper? I think that in future meetings, members will be asking similar questions because not all our members here, some of them are in other meetings. So I hope that we can have a written reply. Yes, I will be willing to do that. And just now, you mentioned that there are over 200 submissions that have been given to the LegCo. And over the weekend, we have already studied those submissions in great details. So when we give members a written reply, we will also address the concerns set out in the submissions. For example, the freedom to exit and enter a place, promotion of publicity, legislative requirements, issues concerning mainland Taiwan, and personal human rights, etc. So in our written reply, all these questions will be answered. I just hope that you won't think we are too long-winded. Now I will ask members to raise questions. We have James Toh, Ray Chan. Each one will have 5 minutes, and then we also have Yu Si Wing and Hu Chi Wai. Mr. James Toh, Chairman. Well, the UN passed such a resolution, and I was sure that this resolution will come to Hong Kong when we have to implement the recommendations here.
And I realized that there will be some difficulty in turning this into law, and that is how we can prohibit somebody from joining certain action. I would like to invite the deputations to comment on these issues because they have taken the trouble to join us today. Of course, if you join an organization designated by the UN as such organizations, then there's no argument about whether we should prohibit it. But it's more than that in the bill. Say, someone goes to Myanmar, the Rohingya, Myanmar from Hong Kong. We go from Hong Kong to Myanmar, and only the Myanmar government regards the Rohingya people as terrorists, but not other countries. But in Hong Kong, our system does not involve the court. So the government can prohibit someone from leaving Hong Kong. The question is, is this done by referring to the UN's list, or Hong Kong SAR government's own list, or the list of Chinese government, CPG, or the list of any national governments?
去嗰度咧，你係嗱，仲有一個要解決嘅問題咧，我想請教即係。
But this is going to create difficulties.
如果你話去嗰度，直情係學一啲行為，即係製炸彈。
If you go there to learn some skills, for example, how to make bombs, it's easy to deal with. Well, you may say that if that's about learning to make bombs, just inform the other authority and has that person arrested. But if it's not yet done, you are just preventing something to be done. You are preventing someone from being radicalized. But if they are just going to learn the philosophy, to be doctrinized, so all it takes is for the other authority in the destination to arrest the person, and that would be it. So if we require certain standard of proof to be met, so if, for example, you cannot say that someone is prohibited from going to another place to listen to certain preaching and sermons, but they have different levels of learning or instruction. Basic level, intermediate level, and so on and so forth. And also, radicalization is a process. It takes it takes time. So if we require a lot of proof, it's not going to work. If a low level of proof is required, it's going to be inconvenient. So what is the role played by this bill and by Hong Kong people and the government to prevent certain things from happening? And we have to be specific about what we are trying to prevent. This is so complicated, and that's why I need a lot of time to voice my concerns. I think some of the concerns have already been answered by the Deputy Secretary. If you want the deputations to respond, please specify to whom is your question addressed. Perhaps I can wait until the second round before I get an answer. I hope the government officials can be patient in listening to our worries, because we do not just make up these concerns. Many people in Hong Kong are genuinely concerned because of the weakness of the bill. Of course, the overriding principle of anti-terrorism and the principle of preventing terrorism before it happens are not something that we are going to argue about. But we do need to look at the provisions, since this is a bill. But of course, it would at the end of the day, the court would have to make a ruling. But the ruling would be based on the bill we pass. The definition of terrorist act is, comparatively speaking, clear. But we're talking about planning and perpetration and preparation of terrorist acts or training. We're not talking about acts anymore. We're talking about intention. Some people are worried that you will blow things out of proportion and you adopt a double standard. Of course, if the organization called itself a terrorism university, of course it would be closed down immediately. They would try to dress it up in some way, such as they would call it a religious institution. let's say I went to a meeting convened by Dalai Lama, a religious gathering. Some people may regard this as a political activity. If I meet the Tibetan government in exile, the Tibetan government says it's not advocating independence, but some people think they are. Would the entire activity or the entire organization be defined as a terrorist organization? If I attend a Zen practice session or I listen to some sermon, would I be regarded as participating in a terrorist training or activity? How can Hong Kong SAR government know about the content of instruction? Even for the university courses, we find it difficult to ascertain what was taught. Some party, media, and some political parties have tried to brand certain pro-democracy activities as independence activities. If I went to Catalan to observe and to learn from what they have been doing, and if they are involved in certain terrorist activity, would I get myself into trouble? Or should people exercise self-censorship? Don't go to any sensitive location. Don't meet with any sensitive people. Hong Kong government is doing a better job than the Macau SAR. They bar the entry of certain people, saying that they are a threat to internal security without further explanation. So you can see that in some jurisdictions can base their action on such criteria. So how can we know the ways different jurisdictions implement this resolution? It said that we are not trying to do anything more than the European countries or the US, and that we are adopting a targeted approach. Mr. Wu Chi-wai, I would like to quote an example and try to get an answer from the government. In Las Vegas, there was a recent incident which many deputations and members have talked about as a lone wolf incident. And then IS suddenly claimed that it had to do with them. If it's a lone wolf incident, how can you link this to terrorism or terrorist act? Some countries would claim that such incidents are isolated cases and have nothing to do with terrorism. So how can we tell whether a lone wolf incident is covered by the law or not? Or are there other laws that can cover such an incident? And we need to know the difference before and after the enactment of this bill. If a lone wolf act is linked to terrorism, what would be the difference if it's not linked to terrorism in case of the way it is dealt with? Well, many members have raised a host of issues, and I will provide a comprehensive response. We're talking about targeting people leaving Hong Kong for a specified purpose. And that is for planning perpetration, planning, or preparation of or participation in terrorist act, or the provision or receiving of terrorist training. Perpetration is about planning for an attack. And planning is more long-term in nature. Participation is about the execution of the action. Every case is different depending on the evidence. Members have referred to the Las Vegas incident, but we still remember September 11th incident. The Islamist terrorists were the one doing the perpetration. They ascertained the flight path, the schedule, and then they slammed the aircraft into the buildings. And then there are also planners doing the planning by booking the flight and arranging for the terrorists to board the flight. And there are people participating in the act, and that is those who took the flight attendants and pilots into hostage. We have no definition in the bill, so we will refer to the general definition. This is most appropriate for the common types of terrorist acts, because the mode of terrorism act or terrorist act can change very quickly, and we may not be able to catch up easily. For this Las Vegas incident, a terrorist act is one of the possibilities. That perpetrator smuggled dozens of guns into the hotel. But we do have a definition of a terrorist act in our law. It's an act that would lead to serious violence, or serious property damage, or they may also seriously affect personal safety of some other individuals. And the intention is to compel the Hong Kong SAR government or international organizations, or to threaten members of the public, or to promote certain religious and political ideas. And under this definition, public protests, assemblies, and rallies are exempted from the coverage. So the specified purpose can cover a lot of things. And under the UMAMO, Section 10, we have certain prohibited acts which we do not intend to amend this time. No one can just ignore that a certain organization is a terrorist organization and still join the organization or receive or accept the invitation to become a member. The UN has a list of terrorist organizations. And in Hong Kong, we have two ways to decide whether someone is a terrorist. Over the years, we have been using the UN list. Let's say IS. If you know this is a terrorist organization and still you have association with this organization, or you join it as a member, then of course it's a problem. What about those people who radicalizes themselves? Some people may have been led astray through surfing the internet. They may become radicalized. And then in the UK, in the US, we have such case of perpetrated by the radicalized individuals, and then whether it's the job of IS, as they claimed, is something to be decided from the internet. We know that in the UK and France, they have amended their laws, and they have taken rather drastic measures to tackle this. For example, France has amended its laws to close down certain radical websites, and they are going to mandate rehabilitation of terrorists or people holding certain terrorist concepts. We're not doing this in the current bill. If necessary, we would move further amendments in the light of UN resolutions and other international cooperation efforts. We have covered the training or terrorist training under specified purpose. Very much will depend on the circumstances and evidence of the case, and prosecution must be supported by the necessary mental elements, the mens rea. We have no intention to amend the definition of terrorist act, but is a criminal intent a weak term?
Well, in the legislation, we have several areas covering this. That is knowing. Well, it means that person knows that this act will lead to a certain result. And how about intention? That means he is aware that this act may lead to certain consequences. And what do you mean by ignore? Well, in the Singapore versus Hong Kong government's case, as for ignoring the consequence, and thus or recklessness is a very clear definition. That is, the person knows that there will be risk. However, he still ignores the possible consequences, still reckless about the risk. So he just ignores the facts and does it. So this is very clear in the Singapore case. Now, a member asked, what if I go to a Dalai Lama gathering? I'm just going there for meditation. So would you regard me as joining a terrorist training? But under the UNLC RS 2178, it states very clearly that this is not. This should not be linked with any religion or other cultural activities. So I don't think you will be implicated. So if there is a need in my written reply, I will set all this out clearly so that you can rest assured. Thank you, Deputy Secretary. Chairman, Mr. Yu Siwing, I just want to ask again because I didn't hear the answer. Now, for the same act, maybe is a serious crime or is a terrorist act. So what are the different consequences? Now, for any act, it may be caught by more than one ordinance. So we have to look at the evidences, and when the relevant authority carries out the investigation, it will collect evidences. So we will have to look at the actual evidence. Yes, we will have to look at the actual case. Mr. Yu Swing, just now the Deputy Secretary, in her explanation, talked about the Islamic State. I think you should clarify that, otherwise there may be misunderstanding. For this bill, I support it. Because there are more and more terrible terrorist attacks, and the frequency of lone wolf acts has increased. Hong Kong is not a high-risk city, but we should be prepared. We cannot take this lightly and delay the passage of this bill. I don't think this is responsible. Just now, the Deputy Secretary said that there will be enhanced communication with the tourism industry. That is really necessary because our industry is very worried that we may be trapped unintentionally. So we need the government to communicate with us. So how will you tell the industry about this amendment bill so that their worries can be allayed? This is question number one. Question number two. Some practitioners in our trade, if they help these terrorists intentionally, of course there is a problem. But how about their bosses? Would their bosses be held responsible too? Well, because you may say that it's your company's staff. You haven't screened them. You haven't looked at the background of your staff. That's why they're doing this. So will the bosses be held responsible too? And thirdly, just now the Deputy Secretary said that now you receive more and more reports. Now, for our industry, if a staff member has such a suspicion, but he does not report it, now maybe he believes that this is a terrorist, he has provided service to the person, and he knows this. So would he be punished because he has the knowledge? Chairman. For our newly added offenses about travel, the prosecutor would have to prove that the travel agency's staff, when he plans and organizes the trip, he already has the intention and he has the knowledge that the travel will be carried out because of the specified purpose, and the burden of proof is on the prosecution. Now, the prosecution would have to follow the standards of courts, that is, to prove beyond doubt. So for the prosecution and conviction thresholds, they are very high. Now, if the practitioner has the intention or has the knowledge that the travel will be carried out for the specified purposes, and he still assists and facilitates such a travel, then he will be regarded as aiding the terrorists. We understand the concerns of the tourism industry. Now, we already have a very good communication platform with the tourism industry, but it's mainly about fraud or the folding of travel agencies. So after the passage of the bill, we will enhance our communication with the industry, and there will be several ways of doing it. First, we will take the initiative to talk to the industry, to explain to them about the ordinance, and then in writing, we will let the travel industry stakeholders know more about this ordinance, and we will do promotion on a regular basis, because this is something that will have to persist. This is a constant battle against terrorism. As for responsibility, I think the bosses do not have to be worried. If the evidence shows that this person does not know that this travel is for specified purposes, then this person will not be convicted. So for our communications with the industry, we will tell industry members categorically what this new ordinance means, and we will be giving you telephone numbers. If you have any suspicion, you can report to us. You are just exercising your responsibility as a citizen when you do so. Mr. Paul Chair and Holden Chow, first round. Mr. Paul Chair. Thank you, Chairman. I have read the submissions, and it seems that people are very concerned about the definition. When we look at the bill, it seems that the definition is not clear and it's quite broad. And you just follow the list of the United Nations. Would that be not flexible enough? Is it too narrow? Maybe the government can give me an answer. And also, just now you cited some examples. For example, Snowden. The government's explanation was like the status. If electronic systems are a factor, they will be included in the definition. I remember back then even some electrical members in Hong Kong assisted Snowden to leave Hong Kong. Well, of course, Snowden may not be a terrorist to some people, but in some big countries' eyes, he is indeed a terrorist. So would the exemption be applicable here? And also, other than Mr. Yu Siwong, Mr. Yu Pak-leung, the district councillor, is also here. He is speaking on behalf of the travel industry. So for the travel industry, do they have the responsibility to ask questions? Now, if you want to book an air ticket to going to a certain destination, for example, Barcelona, well, then things may happen there. So should the travel agents ask you questions? Why are you going to Barcelona? Are you going there to join the independence movement, or you are just boarding a cruise there? So what should they do? And how about air tickets? If they are return trip tickets after departing, and then you discover that this person actually is going there to take part in terrorist acts. So can the travel agencies stop the return leg of the trip? What should the travel agency do?
我嘅專家們，如果你覺得剛才嘅例子你有意見，都請你哋邊個舉手去回應下，唔該。
And I would like to get an answer from either the government or the deputations. Deputy Secretary first. In Hong Kong, there are two ways to specify terrorist association and terrorist property. One, to rely on the list promulgated by the UN. Second, the CE can propose a list and the order be sanctioned by the court. We have been relying on the first approach all the time so far. For the new prohibitions, if we say we just rely on the UN list, there may be a loophole. One day, if we need to designate or specify a terrorist or terrorist associate or terrorist property through the second channel, we may not be able to do it in good time. We should not have a system which is fraught with loopholes, so that terrorists can make use of the loopholes. An example in the form of Mr. Snowden was quoted, whether he would be regarded as a terrorist because he tampered with certain computer systems and so on. We'll look at the act first, and whether the act is terrorist act. and whether we're talking about Snowden or not, or whether a person is a terrorist. There's a clear definition. Act or intend to act as a terrorist or to perpetrate a terrorist act or persons assisting such terrorists. And then we have to look at the definition of terrorist act, which is a clear one. It must involve serious violence, serious damage to personal safety and property, and also the paralysis of important infrastructure with an intent to oppose to a certain government. Yes? Sorry? What about serious interference with an electronic system? Perhaps I should continue.
其實咧，仲會要個意圖係強迫特區政府或者國際組織。
With the intention of threatening a government or international organizations and to promote certain ideas or philosophies of a religion or certain groups. My personal assessment is that your case may not qualify. It may not be caught by this definition. And Mr. Chair is very kind in raising the concern of the industry. What if it's found out afterwards whether the tickets should be cancelled or else the industry will be liable? We want to target criminal elements instead of bona fide travel agents and businessmen. So the prohibition is such that if the industry finds something suspicious, they can call the police or use the direct phone line we provided them, and if they fail to find out such matters, is not an offense. Anti-terrorism efforts require intelligence. The police will investigate leads. So the police may need to get the cooperation from the industry in ascertaining the schedule and the departure days and destination of the suspect. So the police may want to get some information from the industry. We inform the industry after the enactment of dispute. We maintain communication with them. Service providers or other people are not required to ascertain the purpose of the travel of a client because it may have to do with privacy. We're talking about criminals with a serious intent of doing this, and we're talking about providing assistance with intent, with knowledge. Mr. Holden Chow. Thank you, Chairman. I have a question. It's about the intention or knowledge. That is to facilitate or to provide funding for terrorist training. And this talks about any person in Hong Kong or Hong Kong permanent residents out of Hong Kong. In other words, if there are some Hong Kong permanent residents not in Hong Kong providing financial support to terrorist training, since these people are not in Hong Kong, we need to have these people extradited so that they will be tried they will be tried in Hong Kong. In other words, foreign nationals in Hong Kong, if they are doing the same thing, raising funds for the terrorism, would they be brought to justice in Hong Kong? If their countries want to extradite them, provided that there is such an extradition agreement, are we going to surrender them to those jurisdictions? So it is a two-way street. So Hong Kong permanent residents breaking this law in another country will be brought back to Hong Kong to face justice, and likewise, other jurisdictions may want us to surrender their nationals to them, or can they insist on asking the SAR government to bring them to justice? Deputy Secretary, Section 3 may apply to a foreign jurisdiction, and that is Section 7, 8, 9, 11B will apply to anyone in the Hong Kong SAR and any persons out of Hong Kong SAR, including Hong Kong permanent residents and a body corporates incorporated in Hong Kong SAR. These extraterritorial applications would mean that Section 3 applies to persons in Hong Kong SAR and Hong Kong permanent residents not in Hong Kong, as well as body corporates incorporated in Hong Kong. UNSCR 2178 refers to the nationals, but we don't have nationals, so we apply this to Hong Kong permanent residents wherever they may be. Mr. Chow asked how this can be done. If this bill is enacted, first of all, through the criminal law, mutual assistance, and rendition of fugitives, we can handle the cases accordingly. And of course, we can wait until the suspect returns to Hong Kong and arrest him at the checkpoint. But what if the other jurisdictions want to have their nationals extradited? This happens from time to time. There is a negotiation provision here. So if there are concurrent jurisdictions, we can negotiate, we can communicate with the other jurisdiction, depending on which side has the most evidence. Of course, if the evidence we have is weak and we may not be able to secure a prosecution upon his return, we should not insist on the extradition. So this is a new approach that we can negotiate a way out with the other jurisdiction. Mr. Chan Ying, this bill applies to Hong Kong permanent residents, but you know that Hong Kong permanent residents may hold other nationalities. Some of these nations have not joined the task force or the international organization concerned. And if that person does not want to be dealt with as a Hong Kong permanent resident, and he wants to be treated as a national of another nation, can this be put up as a defense? Chairman, Article 24 of the Basic Law defines Hong Kong permanent residents. Chinese national born in Hong Kong, that's the first one. Second, Chinese citizens who have ordinarily resided in Hong Kong for not less than 7 years, and 3 persons of Chinese nationality born outside Hong Kong of those residents listed in 1 and 2, and 4 persons not of Chinese nationality who have ordinarily resided in Hong Kong for continuous periods of no less than 7 years, and also persons under 21 years of age born in Hong Kong, of residents listed in Category 4 before the establishment of Hong Kong SAR, and persons other than those residents listed in Categories 1 to 5. The definition is clear. So we have to look at our mini constitutions on the definition of permanent residence. If someone is defined as a permanent resident like that, and if there is sufficient evidence, we would prosecute on that basis, and follow-up action will be taken on the same basis. Is that clear, Mr. Chan? Yes. Clear.
我睇下議會，因為我其實係問佢哋。
Mr. James Toh, could you please repeat your question in a simple manner, because some 20 minutes have passed since you have raised them. We're talking about terrorism and terrorist act. If we prohibit someone from leaving Hong Kong on the premise that he's going to receive terrorism training, we are on safe ground. If it's about training to perpetrate terrorist act. But for training for the purpose of terrorism, although in the UNSCR it must not be mixed with religion and so on and so forth, but it's not in the bill. This is not in the bill. So the government has considered that this particular reference in the resolution should not be put into the bill. So this religion, civilization, and ideology are left out. And terrorism is not defined by any UN list. Any response? Mr. Zhang Shaoyin, the definition is problematic. Under Section 4 and then Section 5 of the UN AMO, terrorists designated by the UN Security Council, and the CE can apply to the court to designate someone as terrorist. The government follows the UNSCR 2178 in relation to a terrorist act. But for 3C, specified purpose, planning, participating in one or more terrorist act, we have a clear definition for terrorist act. But what about the terrorism organization involved in such terrorist act? There are different terrorist organizations. There's a list that defined by the UN, but some governments do not specify all of them. For example, they may designate some Uyghur organization as a terrorist act, such as the East Turkestan organization. Different countries have different organization as terrorist organizations. For example, Turkish government designates a Turkish Communist Party as a terrorist organization, and Japanese government has designated the Om Buddhist sect as a terrorist act. And then there are other African organizations designated as terrorism act, and also Hamas is to some countries terrorist organization, but it's not in the UN list. And the Uyghur youth organization has in its manifesto the promotion of non-violent non-violence behavior, but it's called a terrorist organization by some government. We are trying to act in accordance with a UNSCR, but it's not clearly defined for specified purpose. We should adopt the standard of the UN Security Council. But for terrorist organizations, it's rather weak because different countries have different standards. Unless we have one for Hong Kong SAR. Otherwise, we're part of the PRC. So we have to follow the standard of China or the UN, or because we are supposed to amend domestic legislation in accordance with UNSCR. So perhaps we should follow the spirit of the UN first.
朋友
Mr. James, so do you want the government to answer you? Well, I think we should also listen to other delegations, but because I think they should be using today's time. Mr. Pang Chua-fu. Oh, please make it simple because it's overrunning. Well, just now I heard members' comments, and in particular I've heard Mr. James Doe's questions. I think he's a bit over the head because Hong Kong is a safe city and Hong Kong is open, but there are now so many terrorist attacks all around the world. It seems that we are susceptible to all these attacks. Now we are looking at the amendment bill. If we can follow the UNSC's resolution, I think we should move forward in this direction because we do not want an attack to happen and then we would regret we didn't take any action. In 2014, the US took the lead and France as well as the UK have done something. They have tried to prevent the flow of citizens. In case they are related to terrorism. Well, the whole world is doing this. Hong Kong shouldn't lag behind. Well, as for the detailed legal points, I think we have many experts, but this is the general direction which we should follow. Under Secretary, I would like to tell you about some background for the UNSCR 21778. When it comes to the prohibition of travel, it suggests that now if you are going to provide or receive terrorist training, the relevant travel should be prohibited. For the Security Council's resolution, well, it's not that strict. It doesn't mean that we have to follow every single word of it. And we just want to allay the worries of Hong Kong people. We do not want to harm the innocent people. Some religious people may also want to go overseas to have some exchanges. So now we are packing it to a terrorist act, not terrorism. Well, for terrorist act, as I said several times before, we have a very clear definition and there are some exemptions. So it will protect Hong Kong people better, it's clearer. And we do not want to see loopholes as well. If it's pact to terrorism, then it's very vague, and then you have to define what terrorism is. Well, for Australia, they also do this. That is pact to terrorist act. We think this is feasible. Well, in the past, we talked about Islamic State, Osama bin Laden. In recent years, we have seen numerous incidents done by lone wolves. Maybe they even haven't joined a certain terrorist group, although IS states that it's their act, but maybe they're just taking advantage of the incident. So if you pack it with terrorism, then it will be a big loophole. But if you link it with a terrorist act, as long as people are killed, properties are damaged, it can be regarded as terrorist act. So it's better for us to take action against lone wolves. It will be more effective against strange tactics. So don't worry too much. Now for terrorist organization, Section 4 and 5 of the ordinance already state very clearly what terrorists and terrorist associates are. For terrorists, it's not an individual. It can also be an organization. So we already have a list of these people, companies, organizations, etc. For example, a certain company, it may be a terrorist associate, it may be funding terrorists, and it's already on the list of the UN. So for Hong Kong, we have a very robust system. So we do not want to say that these terrorist organizations designated by the United Nations, then that would not be flexible, because in the future our CE can also ask our court to designate certain terrorist organizations. Well, our meeting should end at 11, so please leave me 1 minute for other business. Mr. Ray Chan, just now the Deputy Secretary didn't answer Mr. Chang Sao-Yun's question very clearly. That is about terrorist organization. For example, the mainland governments have designated certain terrorist organizations, but some of them are not on the list of the UN. So would the SAR government use this as a reason at the court? And the court would not have a choice, because this organization is already on the mainland list. I know that the Deputy Secretary wants us to allay our worries. She says that they use Terrorist Act because it's stricter, and then there are exemptions. So you have to trust the court. So an organization, if it's not caught by the definitions, then it may be exempted. I think our perspective is different from that of the government. The government wanted to be more lenient and broad so that they don't have to come back all the time for amendments. But we want it to be clearer, we want it to be narrower, so that the public can rest assured, because then it's not open for interpretation. And then the court would not be forced to do certain things because due to pressure. Thank you for your view. Well, for a lot of important issues, our court is the gatekeeper. We uphold the rule of law. As for terrorist acts or terrorists, this is a very important issue. In 2002, this council discussed this, and I have read the papers. It originally suggested that the CE could designate, but then this council said that the gatekeeper should be the court. So that's why it's incorporated in the law, and we have the presence mechanism. So for this amendment, we are not going to change this, because it was a wise decision of the Legislative Council. At that time, we also agreed to that. So what standards would the court use? The CE would need some important evidences. He should think that this essential, so he will start to do that. Well, up to now, this section has never been invoked. Yes, it doesn't mean that it will never be invoked in the future. We all understand that. But if indeed such an application is made, we understand that the court will do the following. The court would balance probabilities to consider the application, and it would consider the acts of the person under application and whether such acts are in line with the definition of terrorist acts. Well, let me ask my question clearly. Now, if the Beijing government designates certain organizations as terrorist organizations, would the government have to follow suit? And there's no room for the court to review the case. Now, if this really happens, that is, the CE would make an application to the courts, and the court will look at the factors that I mentioned just now. So the court will still have room to maneuver. Even though the Beijing government adds new organizations to its list of terrorist organizations, then the court would still have to follow the procedures and standards you mentioned just now. And they would really have to look at the act and whether the act can be regarded as terrorist act. Mr. James Toh, on this issue, I hope the government can give us some information in writing. Chairman, give me 20 seconds. Yes, I will be glad to do that. Let me cite an example. For example, there's an organization X. So there is an organization X in Hong Kong, and it maybe is in hiding. Now, if you have made an announcement concerning this organization X, but some other people may think that it's too easy for you to designate this organization as a terrorist organization. So can they join the action as friends of the court? I think that would offer a better protection. Yes, I know Mr. Paul Chair has raised his hand. I didn't say that we would extend this meeting by 50 minutes, so our meeting should end here. If you want more information from the government, please write to me, and then I will relay your views to the Security Bureau. I'm sure they will be happy to answer your questions. Deputy Secretary, for our questions and comments today, please take them into consideration. And some questions were asked. Please give us answers in writing, and also for the submissions, you will be providing replies, right? I would like to thank the deputations for coming here today, and members, thank you for attending the meeting. The next meeting is on the 6th of November. It's a Monday, 2:30 in the afternoon. Thank you.